Spousal support may be modified if there have been a substantial and unanticipated change of circumstances which would lead the court to consider the award inappropriate. Take a look at the judgment awarding support. If the spousal support is awarded for transitional or maintenance support, the change of circumstances can be based upon the improved economic circumstances of the person receiving the support, or the worse economic circumstances of the person paying the support. If the order is for compensatory support, the focus is solely on the worse circumstances of the person paying the support. If the judgment does not state what kind of spousal support it is, it will be presumed to be maintenance. 10 years after the judgment, the person paying spousal support can bring an action to see whether or not the person receiving support has made a good faith effort to become self-supporting. A change of circumstances does not need to be proven in that sort of case. The person receiving the support must be under the age of 60 for this 10-year review to apply. Remarriage of the person receiving support does not automatically terminate spousal support unless there is such a provision in the judgment which the parties agreed to at the time of the divorce. But a remarriage may be a factor the court reviews in determining whether there is a substantial and unanticipated change of circumstances, and if so, what the proper support amount should be. Spousal support can only be modified during the term for which it's owed. If support gets changed because of a particular circumstance which goes away, the support can be restored in part or in full upon motion. Let's talk about preparing for your hearing. A Uniform Support Declaration, which we call a USD. If you were the one who obtained the show cause order, you already did one of these, but review it to make sure that it is current and an accurate statement of your monthly income and expenses. If you are the responding party, get this form online or from our Family Law Assistance Program and complete it, showing your monthly income and expenses. Bring the USD and all attachments to court with you. Mail a copy to the opposing party at least 10 days before the hearing. B. Attachments and additional information. Bring your most recent pay stubs with year-to-date information on it. Bonuses, per diem allowances, deferred income, housing, vehicle allowances, all overtime get added to the mix. Be prepared to show when bonuses are paid so that they are accurately calculated. Bring your tax returns including W-2s, 1099s, and all schedules. C. Health insurance. If you provide health insurance, bring evidence of how much you pay for your own coverage, as well as any child's coverage. Get a rate sheet from the benefits provider which shows the cost for an individual and for the other dependents. D. Life insurance. Bring a rate sheet showing the cost of life insurance. If you applied and were denied insurance, bring that evidence. E. The last support order. Review a copy of the last support order to make sure that there will be a substantial and unanticipated change in circumstances since that order. F. Self-sufficiency. If you're receiving spousal support, be prepared to present evidence of how you have tried to become self-sufficient. If you've applied for jobs, prepare a list of when you applied, where it was, for what position, the compensation, and what the result was. Now, if you're physically or mentally disabled, you may need to present expert evidence on that issue if the motion is based on that 10-year after judgment, or it's based on your reduced need for support. G. Economic downturn. If you are paying spousal support and have encountered a substantial economic downturn, you should be prepared to show what has happened to your job and your industry. Now, just because the person paying support has a greater income does not mean it's considered a change of circumstances unless the judgment specifically states that the spousal support is insufficient to meet the needs of the spouse receiving it. H. Try to settle your case. The parties can work out an agreement which goes outside the box. Unless there's some restraining order prohibition, you should discuss settlement with the other party before you come to court. The other side won't talk to you Ask the judge to instruct the parties to talk before the hearing goes forward to see what can be worked out. I. Mark your exhibits. Each document should have its own sticker. Petitioner has numbers 1 through 99. Respondent is 101 through 199. J. Make copies of your exhibits. Ideally, you have 4 loose-leaf notebooks, one each for the judge, yourself, the opposing party, and the witnesses, with copies of all of your marked exhibits. The originals, which could actually be copies but have original exhibit stickers, go to the court's clerk.